Dear guests, welcome to Sorainen webinar on labor market restrictions. My name is Kaupo Lepasepp. I'm country managing partner for Estonia and also competition lawyer here in Estonian office. It is my utmost pleasure to welcome you all here on our webinar. And I see that we have registered right now, or we have present here 94 participants. So it's a great responsibility for us, and we hope that the webinar will be really useful and exciting opportunity for you all. Usually, our employment law webinars are extremely popular, as employees are important and talent pool is critical in many businesses. Unfortunately, this time you all who have registered and who are attending this webinar, you have fallen a victim of misleading advertisement. We used our extremely strong employment brand, but use it as a Trojan horse to introduce you to equally prominent competition practice. No worries, those who feel that you have been wronged, you can give us afterwards feedback and ask for a good webinar on misleading advertisement sometime in the future. But this webinar will focus on a mix of competition law, but also employment law. We will talk about tools which are used for many years, decades, to protect our talent pool, to protect our sensitive know-how, and to protect our business contacts from competitors. No poaching agreements, no solicit agreements, wage fixing agreements. Especially the two first are quite commonly used, but at the same time, they are restricting competition, access to resources, they're restricting free flow of ideas and resources. Are they legal? How to use them? Should you have a bag packed with prison clothes if you use them? You will hear it today from the lawyers, from economists, from practitioners, from the authorities. You will hear from decades of experience and knowledge from the market. And this will be also a good starting point to forecast the future and developments in the future. We will focus on the Baltics, but we will also cover European Union, and you may hear words like USA, UK, and many other countries as well. So be ready for a truly transatlantic experience. To make the best out from the webinar, we really encourage you to participate actively. If you have any questions, please ask them on the right side bar in the chat. We will either respond these orally after the presentations, or during the presentations, or during the webinar in the chat. We do our best to respond to all questions. But if the question takes a longer analysis, we may choose to give feedback in a later point. And our team will remain at your disposal. In the presentations, you will see email addresses. You're always welcome to ask the questions from them directly if you feel that the question may be a bit too sensitive for a wider discussion. So participate actively. And now, welcome once more. And I give floor to my colleague from Lithuania, Auridas Litvinas, and he will give us an overview of what this webinar is all about, what are the restrictions in the labor market, how to quantify them, how to classify them, what are they. So Auridas, feel free, floor is yours.
Thank you, Kaupo. So while the conclusion of my presentation is kind of in the title, it will be that currently it seems like there's very little room for lawful labor market restrictions, but I will cover this from the EU law perspective. So this will largely be based on the current opinion of the European Commission, which means that the same policy is likely to be followed in all member states. But first of all, we have to go through some terminology to ensure that throughout the webinar, everyone is on the same page and does not confuse anything. So when we talk about labor market restrictions, there are two main groups of them. Wage fixing agreements, which would be an agreement between two companies to, for example, not pay a certain type of employee more than 2,000 euros, or not compensate a certain cost to them. Now, we will not focus on these agreements in the webinar. The reason being that we don't really get that many questions about them from our clients, and it seems quite straightforward that such agreements are unlawful. It's, you should, in the same way that you should not fix prices, you should not try to fix the wages of your employees. It's quite simple. Now, no-poach agreements, this is a general term for all kinds of agreements that are related to kind of hiring or trying to gain new employees. So, for example, a no-hire agreement would be an agreement between two companies to not actively or passively hire each other's employees. A different agreement would be a non-solicitation agreement where only active hiring is prohibited. So the difference is that, for example, if you don't solicit, that means that you don't call the employees of the other party, you don't email them, you don't try to invite them. But if they respond to your job advert, you can hire them. Whereas in a no-hire agreement, that would also be seen as, not staying true to the agreement. These agreements, they can be binding on only one party or both of them, and they can be standalone. The other term's called naked, which would mean that it's just an agreement that only has, one or two clauses, don't poach my employees. Or they can also be part of a different main agreement. For example, you could have a services agreement with your IT services provider, and there could be a clause down there somewhere that you are expected to not poach their IT engineers. And again, to repeat this point, we will focus on no-poach agreements because they are trickier. We get more questions about them, and there could be more room for perhaps making them lawful. Now, another thing to stress at the start is that labor market restrictions have only become a recent priority for competition authorities. If you were to take our competition law textbook, especially from some years ago, it's possible that you would not find much, if anything, about labor market restrictions. But what changed is that, especially in the United States of America, economists have found plenty of evidence that these restrictions, they are really common, and they have a negative effect on the economy. So once those studies were published, first in the US, then in the EU, competition authorities came out publicly stating that this will be our priority now. We will try to find these agreements, we will try to investigate them, and we will punish companies for them. However, this being a recent priority means that there's lots of unanswered questions. We don't really have any EU-level decision yet. In this case, EU level means published by the European Commission. We don't have any EU-level cases, that is anything clearly from the European Court of Justice or something like that. What we have currently are local decisions or local cases, and even then, those are usually still on appeal in the courts. So with a lack of practice, we have some statements from competition authorities, we have some cases, some, for example, EU decisions that touch perhaps on one or two aspects of a labor market restriction, but there's still a clear lack of practice. And the reason this is problematic is because businesses can have a kind of legitimate reason to make no-poach agreements. Usually they would try to justify them by the rationale that you can see in the slide, like protecting training costs, their IP rights that do not have patents, confidential business information, which would all be lost if an employee is poached. So the idea is that if you allow companies to freely poach each other's employees, a company may have less incentive to invest, for example, into training, into their IP rights, and so on, because there's a risk that a competitor can kind of quote unquote steal it quite easily by just poaching over an employee, right? So if, for example, there's like a standalone naked no poach agreement, just don't take my employees, perhaps that's harder to justify. But if there's, for example, an IT services agreement, and you know that, for example, a company's IT engineers will come into contact with a different company, kind of like a poaching opportunity, they get to know each other, and you may have less incentive to invest into these employees. So this would be one of the possible basic rationales as to why no poach or no solicitation agreements could be needed. And with this in mind, with the lack of practice in mind, with the possible justification in mind, this year the European Commission issued a policy brief. A policy brief is not a legally binding document. It's basically the opinion of the European Commission, which is not the court, and it's not even an official decision. However, what it does provide, it provides, well, their opinion, which is also useful. It gives us a way to see as to what they are thinking, and how a potential no poaching agreement or another labor market restriction could be seen by the European Commission. And our first reaction in our law firm when we read the brief was that the brief is actually really strict. And the main point of it is that labor market restrictions are restrictions by object, which is a competition law term, which we can basically summarize by saying that this is a restriction that is seen as so obviously harmful that just agreeing to not poach each other's employees can be punished. Even if you never enforce this agreement, even if you would have evidence that you actually did poach each other's employees, you just had an agreement that said you would not, you can still get punished with those hefty fines of millions of euros. And another important takeaway from the policy brief is that it states that labor markets restrictions are unlikely to be justified. So, of course, it does not say that they are never justified, but it simply states that they are unlikely. And the main reason for stating that is how the European Commission holds the view is that companies will have alternative ways of protecting their investment, into training costs, into IP rights, and so on. And these no poach agreements are not really necessary, and there are, other more preferable ways for businesses to reach the same goal. So now we will go into the legal details of how this works. So, for example, even though, let's say, you have an agreement that restricts competition, there is this exception, so to say, called the ancillary restraint doctrine. A very simple example from the European Court of Justice's case law is that there has been a case where an athlete was disqualified for failing a doping test, and he hired some cunning lawyers that thought, well, actually, this is a restriction of competition. If you ban someone for failing doping tests, you have, well, less athletes compete. You actually disqualify some very good athletes. But the court said, okay, look, you can ban athletes that fail their doping tests. The way they came to this conclusion legally is basically there's this doctrine which says that if there is some legitimate aim that you are trying to achieve, that's not restricting competition, like ensuring fairness in sports, right? Ensuring that athletes do not take doping. But in order to enforce this main goal of yours, you need to restrict competition. It's impossible avoiding it, right? So if we go back to that example, you need to ban those athletes that do not uphold the rules. Then you can restrict competition. Basically, if the restriction of competition is necessary for some other goal, then you can have it. But if it's a strict legal test, it has 4 parts, but the 2 most problematic ones, which will always come up, is this rule that restricts competition really necessary? That is, would this main agreement not exist without it? For example, could you have, sporting rules without doping rules? And is that clause, that rule that you are trying to enforce, is it proportionate? So the key question is always possible alternatives. Can you achieve the same goal that you are trying to achieve through another measure? So if we go back to labor agreements, the lawful aim that the business is trying to achieve could be protecting their investment. But the question is it necessary? That is, let's say you have an IT services agreement that I keep mentioning. If you cannot have a no poach clause there, would you not conclude that IT services agreement? Is it really necessary for you? And are there no other ways of protecting your investment into the employee? So the European Commission says that labor market restrictions are unlikely to be considered ancillary. That is, it is unlikely that they can make use of this exception. And they argue that the reason for this is that there are alternatives, which they list in total 5 of. For example, non-compete agreements with the employee, non-disclosure agreements, obligation to stay with the employer for a minimum period of time, through payment of training costs and gardening leaves, like ensuring that the employee has to take a break when he leaves work. The idea being that this can protect training costs, IP rights, and so on. Now, another exemption that you can try to rely on when there's a restriction on competition is Article 101(3) of the Treaty of the Functioning of the European Union. A mouthful, but basically, when you limit competition, you can try to argue that actually this restriction of competition has benefits to the consumers, which outweigh the negative part. So an example of this could be the alliances between airlines. They have certain agreements there which do restrict competition, but they also have benefits to consumers. For example, when airlines coordinate, they can ensure layover flights. They can coordinate the timetables and so on. So again, there is another exception. It's also transposed into national laws. But the problem is that it has very strict conditions, and we did not list them, but one of them also requires necessity. That is, you have to prove that the restriction of competition is absolutely necessary for this gain that you are trying to achieve. So I just summarized these, in 2 separate slides, and we'll discuss them together because I think that it ultimately comes down to the same question. What are the alternative ways of protecting your investment, and do they work? Because if there's an alternative, then you cannot benefit from either exemption, I think, and neither the ancillary restraint ones nor the Article 101(3) exemption. And then we get to the issues part. Now that we have summarized the European Commission's position, issue number 1 is that the brief is a policy document. So like I said, it is just the European Commission's opinion. And it is not yet, has not been used, in a court case. It has not been approved by the courts. And it is very well possible that the courts could take a different view. For example, this story is kind of what has happened in the US. Currently, in the United States of America, their competition law enforcement agencies, so to say, has taken a very strict stance against no hiring agreements by basically saying that they are never lawful, to put the story shortly. However, when this issue came to the Federal Court of Texas, the court had a different view that no, this is too strict. There can be circumstances when the agreement could be justified by the need to protect investment costs. And the case is still in the court, it's still developing, but we have already had a precedent, right, when the view of the authority, which, in some cases can be like a prosecutor, is different from the view of a court who has the final say on what's lawful or not. So even though we have this document, we can see that it takes a very strict stance, and it's not the Bible yet, so to say. It could be that in a year or 2 or 3, we'll have a court decision that will be lighter, or perhaps have a different explanation as to what's a reasonable alternative. The second issue is whether these alternatives are really less restrictive. So if we go through the brief, perhaps the main alternative that the European Commission mentions, and the one that's logical, I would say, is a non-compete agreement with your employee. So instead of agreeing with your competitor that you do not poach each other's employees, you just have a clause in your employment contracts that your employees, they cannot, leave and work for a competitor. Now, the problem, well, or perhaps one issue to discuss, is that it's not clear if this really is less restrictive for the employee, because a no-poach agreement between 2 companies eliminates one potential employer for the employee, whereas a non-compete agreement, it eliminates all possibilities to leave. Now, the European Commission's view is that this non-compete agreement with the employee is preferable due to its transparency. The employee will know about it. Usually agreements between companies, they are secret, employees are not informed about them. So the idea is that when an employee knows that he cannot go anywhere else, he can demand a compensation or something like that, he can, refuse to sign it. He has options, but basically this is the main argument of the European Commission in the paper, that, well, this alternative is better because it's more transparent, but it's not yet clear if it's really, less restrictive in the sense that it ensures that there's more movement, so to say, in the labor market. Then there's the third question, are these alternatives really suitable? One problem with, for example, this alternative of a non-compete agreement with an employee is that it can be much more difficult to enforce. And even if you enforce it, the question is, what can you really get from the employee? So let's say you have a non-disclosure agreement with the employee and he breaks it. Well, it depends on the local labor laws, but sometimes the compensation that you can get is limited, quite really limited. Whereas if you have an agreement, if you had an agreement against a company, it's much more likely that you would get much better compensation, perhaps one that is much more in line with what the harm to your company is. Another problem is that it always depends on the national local labor law as to what you can agree on and enforce, which we will get into later in this webinar. But the point is that when the European Commission's brief just states, well, these are the suitable alternatives, it doesn't really discuss them. It just states them that they exist, and there's no further exploration of, will they really work? Will they work in all cases? When could they not work? And this leads us to the last point, which is kind of right, but there are no specific examples given by the European Commission as to when the no-poach agreement could be justified. So the brief states that they are unlikely to be justified, but there, like I said, there's nothing in there which would give you a clear answer. Okay, so when can I do it? So, for example, this last bullet point that we have in the slide is an interesting scenario that we have thought of. Let's say there's a company that's a staffing company. So for an example in Lithuania would be Biro, but we probably have something similar in other Baltic countries, where the premise of a company is that they hire usually students or part-time workers for themselves, and they offer staffing to other companies on like large-scale or temporary projects. The idea being that the company, the client, gets in contact with a staffing company. It says that, look, we need 20 employees this Saturday to help us on a project. Then the staffing company calls these employees that they have an agreement with, these part-time workers, these students, that, hey, there's a project on Saturday, and they all arrive at the same spot, and we work on the project. Now, for the staffing company, their entire business model is that they have these agreements with the employees, and they have their contacts, they can gather them, everyone in one place. And if you, for example, hold the stance that this kind of company should have a non-compete agreement with their employees, there's a problem, because it is very likely that, based on local labor laws, you will need to compensate employees for non-compete agreements. These employees are likely minimum wage or close to that. If you add a kind of compensation to them, their costs become so high that it could be so that the staffing company becomes completely uncompetitive. It's just the business model doesn't work. There aren't really any like training costs or confidential information to protect. It's quite basic manual labor. But if you allow the client, that is the company that hires the staffing company, to just poach the employees, they can kind of just hire all of them, use them for their own projects, and kind of remove the staffing company as the middleman. So this could destroy their business model, essentially. And at least in our view, this is one example where to us it's not clear. Could you justify this as an ancillary restraint? Because it's a very different kind of example from an IT services agreement or something. And it could be argued that, well, it's kind of like the doping case. It's an ancillary restraint. If they cannot agree on a no poaching clause between the staffing company and the client company, the business model can get ruined. It just doesn't work. They really need that clause. It is necessary. And otherwise, the main agreement, so to say, the agreement to provide those services at all, would not be signed. Another question that we have had is, what if the employee refuses to sign, for example, a non-compete agreement or any other agreement like a non-disclosure agreement and so on? How much effort does a company have to put in to really be able to say that this was not a suitable alternative, right? Let's say the employee says that he will only sign this agreement if he gets a compensation. Okay, how much? How high does the company have to go before they can finally say, okay, this was not an alternative, we needed a no-poach agreement? So these are, at least some circumstances where we are not sure if can this really not be justified. But because the brief says nothing and has no examples, we do not have any court cases, we are kind of left in the dark, and we can think of some arguments, at least in these cases, that it could be justified. But ultimately, we do not have a clear position from the enforcement authority that this would be okay. So there's this gray area, so to say, where we have to wait for more clarity or take the risk and sign the no-poach agreements. So this would conclude my presentation, and the main takeaways are that labor market restrictions are a new trend and a new priority for competition authorities. And this lack of practice, it leaves uncertainty. The main document that we have, which is the European Commission's policy brief, it takes a very strict view. It has no specific examples of when these restrictions could be justified, and the key question will always amount to the alternatives. Are there any? Are they suitable? Can they work? If they can work, a no-poach agreement cannot be justified, but there may be some circumstances, at least in our view, where there are no suitable alternatives.
Thank you, Auridas. Thank you for a really good presentation. You really managed to raise the energy level and the enthusiasm. You received also one question. I encourage you to look in the chat and provide responses. But actually, we have time if you can take it orally. But the Auridas managed to attract 50 more guests to our seminar. So thanks for the great content and good energy.
Okay, Kaupo, I can actually take on this question because I finished my presentation a few minutes earlier.
Yes.
So basically, the question, I will summarize it, is that the person who asked the question is saying that for non-solicitation clauses, it's crucial to determine if the parties are competitors. So if you include non-solicitation agreements in an agreement between, let's say, a service provider, like an IT services agreement, it should be okay. So actually, as I was presenting, I realized I did not stress this enough, but I kind of went over it. So this is a very good question. The way competition law looks at this particular issue is they look at it from the purchasing market. So even if there is an IT services provider and a supermarket that buys these IT services, competition law would say these companies compete for employees when they purchase them, right? Purchase their services. So they are competitors. And they treat these agreements mostly the same, right? So if it's a no-poach agreement between two supermarkets or a no-poach agreement between a supermarket and their IT services provider, both can be unlawful because both are seen as agreements between competitors who compete for the same workforce, even if the end product is different. So I hope that answered the question.
Thank you. I think it should be clear now, although the message may not be the one of the liking of the person who asked the question. But now thanks to the previous presenter, and now we have heard lawyers. Now let's look into what the economists have to say, and it's my privilege to introduce the next speaker, Kalle Kandanen from Copenhagen Economics, senior economists, and will be continuing on the similar topic and the economical aspects. So Kalle, please, floor is yours.
Thank you, Kaupo, and thank you for inviting me to bring the economist's perspective on labour market restrictions. So in the coming 10 minutes or so, I will explain why employers are interested in labour market restrictions, how these restrictions can impact the economy, give a quick overview on a few existing cases from Europe, and we'll finish off by giving you some advice from an economist's point of view to take home and into consideration if you think of using any kind of labour market restrictions. So before I dive into the topic itself, let me briefly introduce myself. So as Kaupo said, my name is Kalle Kandanen and I work as a senior economist at Copenhagen Economics in Helsinki. So Copenhagen Economics is a consultancy with one specialization, economics. And we are experts in competition and regulatory economics and help our clients across a range of industries. So while this has already been covered to some extent by Auridas in his presentation, I want to briefly remind us again of the types of restriction we're talking about here. So a labour market restriction is any agreement or restriction that affects competition on the labour market. And they can be either classified as horizontal restrictions when they take place between two competitors on the same market, or you could think of them as a vertical restriction where it's more in a service agreement, as discussed before, between a buyer and seller. And at least in my view, in these cases, these may qualify as so-called ancillary restraints, in which case the restriction itself is not the main contract, but a necessary part of a wider agreement. So the main question, and also the subtitle given to my presentation, is why are employers interested in labour market restrictions? And I can give you 3 answers. The short one to this question is that labour market restrictions increase employers' profitability and decrease their uncertainty over their employees. The slightly longer answer to the same question is a bit more elaborate. So labour market restrictions can incentivize employers in providing their employees with training, as the employer can be more certain that the knowledge gained by the employee will actually benefit the company and the training and the benefits of its stay, so to say, in-house. They can also help employers maintain their trade secrets and protect other sensitive information which the employee may gain, and they can help employers reduce their labour costs. There is also a third and a definitely wrong answer, that labour market restrictions help employers decrease competition in the labour market. So all good so far, but the reality is that labour market restrictions can also have wider impacts. And in the coming, I will discuss wage fixing and no-poach agreements in a bit more detail. So in wage fixing, employers, so in other words, buyers of labor force, agree on a wage level that is lower than the competitive wage level. So they aim to set wages at what is called a monopsony wage level. At this lower wage level, not all employees are willing to provide their labor to the market anymore. And this leads to decreasing output. And this decreasing output then means that in the end, there's a risk of increasing consumer prices. So even if the restriction itself happens on a different market, it can trickle down all the way to consumer prices and harm consumers and harm the economy as a whole. And this is a situation comparable to a monopoly that sets a higher monopoly price that then decreases demand for the output. But in this case, the buyers decrease the supply. At the same time, the wage fixing agreements can actually reduce the risk of wage inflation and result in decreasing consumer prices by decreasing the production costs of the company. And where the balance between the positive and the negative ends really depends on the level of competition across different markets. So for instance, if we suppose that there is a shortage of labor on one market, it is possible that by wage fixing, companies can avoid wage inflation in that market, which then in turn would result in lower consumer prices as long as the downstream market is competitive enough. So it's not obvious that wage fixing is always resulting in consumer harm and damaging the economy. Moving on to no poaching agreements and clauses. As mentioned already earlier, these can be either between two competing firms horizontally or part of a contract in a vertical relationship between firms. So on the downside, no poaching agreements can run a risk of decreasing innovation in the economy because they prevent so-called innovation spillovers, where employees, labor force changing jobs, take some know-how from one employer to another and then combine it with the existing know-how at the other company. Furthermore, in particular, horizontal no poaching agreements can lead to non-optimal distribution of labor, meaning that employees don't actually work with the employer that would best match their skills and also best match their value. But then, as I think already discussed, they also provide employers with increased incentives to provide training to their employees, because they are sure that they will also benefit from the training. And the agreements can also help firms protect their trade secrets and sensitive information, which then in turn can ensure that the company remains competitive in the market. So summing up, while labour market restrictions can foster development, help firms innovate and limit costs, they also run the risk of restricting labour mobility, which can then impact the economy negatively as a whole. So then briefly looking on the case law, there aren't that many cases and they are primarily investigated by national competition authorities. But in the last decade or so, there have been 15 cases. And here there's a brief summary describing what type of cases they have been. Out of these 15, most are concerning no-poach agreements between companies, and all but one of the agreements were horizontal between two or more competing firms. These cases range from different sectors, from flooring to real estate, but quite a few of the cases actually concern professional sports, so they might not necessarily be that relevant for most of the audience. But a list of these cases is also appended at the end of the presentation. So the case practice around labour market restrictions is rather limited. And in most cases, the competition authorities have found the restrictions illegal. To me, I don't interpret this actually as nearly all labour market restrictions being bad, but as a sign that we gain very limited information on the cases that were never brought forward and where the restriction was considered lawful. But the policy brief published by the Nordic competition authorities actually provides one example where the competition authorities deemed a labour market restriction legitimate. So in Sweden, healthcare is provided primarily by regions who face significant shortages of qualified nurses and doctors. For the professionals themselves, it can actually be tempting to work through staffing agencies rather than directly for the regions. And this is because the health professionals' bargaining power gives them significantly higher wages if they work through the staffing agencies rather than the collective agreements used by the regions. So in response to this staffing issue, the staffing problem, the regions introduced a contractual deferral period of 12 months, which forbade the staffing agencies from using health professionals as temp workers at their former employer. So the agreement limited the freedom of movement of labor in this case. And my interpretation is that this restriction was put in place to limit the increasing cost of using temp staff in healthcare, and that the likely aim of the restriction was to reduce the incentives for the healthcare professionals to quit their jobs and work through the staffing agencies rather than for the regions directly. And the Swedish Competition Authority, despite of numerous complaints and other investigations into the healthcare and staffing in healthcare markets, did not investigate the case. And my interpretation from this is simply that the restrictions in this particular setting were considered appropriate given the purposes of the agreement of reducing the labour cost and ensuring affordable healthcare in Sweden. So last but not least, as a final takeaway, I want to say that while the European Commission's policy brief on labour market restrictions has a rather strict stance on labour market restrictions, as described by Auridas, it is important that you actually make a case-by-case evaluation on the need for the restrictions. So whenever you consider using labour market restrictions, you should ask yourself the following questions. What is the purpose of the restriction? What benefits you gain from the restriction? Absent the restriction, would your behavior be different? how widely are different types of restrictions used in your industry? Is it necessary to cover all employees in the restriction clause? And what are the benefits of the restriction for others? So not for you, but for others. And now I want to thank you for your attention, and I believe we still have some time for questions from the audience, if I'm correct.
You're absolutely correct. Thank you for a very good presentation, and thank you for a very practical checklist on how to understand the risks associated with the restrictions. But does anyone have any questions to Kalle? I cannot see any restrictions, any questions. No restrictions as well. So everybody are welcome to ask. Kalle, may I get back to your checklist? The final point in your checklist, among if I remember correctly, among 6 or 7, was that what are the benefits that others are gaining from these restrictions? I mean, can you elaborate on that? What kind of benefits can come to the others from a restriction? For instance, if let's say what good is there coming from a non-poaching agreement for the society or employees, or for that particular employee?
Yes, so in this, I refer to the 1013 conditions that there needs to be a consumer benefit.
Mm-hmm.
And this consumer benefit can come in a form of, say, the no poach is required to ensure innovation in the company.
Mm.
Or if it's say a joint research between 2 companies, that you would not dedicate those workers, those researchers for the project unless you were certain by a contractual clause that your competitor won't poach them the moment they've been introduced to those employees. So the benefit can be indirect. It doesn't need to be direct, say, lower price, but it can be innovation and the firm not investing absent the contract.
Okay, but if you look at your practice, do you see that these indirect positive effects usually are there, or are they like invented afterwards if somebody is asking questions? What's your general feeling?
I am afraid to say that often firms don't think about these questions enough. When they enter agreements, whether that is a labor restrictions or other contractual terms, they often don't think upfront, why are we actually doing this? But might include a standard clause and then find out later that it can be problematic.
Okay, but thanks, Kalle. Here we got a first homework for the audience, that those who are using these labor market restrictions, please take some time to reflect. Why are you using and why are these restrictions practically needed? And to give more food for your thought and homework, we continue with the webinar. Thanks, Kalle. And now I introduce a panel discussion on regulatory perspective, practice and views of the local competition authorities. So we have heard legal theory, we have heard economics theory, but now let's hear what the authorities think, because ultimately their opinion matters. So please hear Eugen Elison-Kask, case handler from Estonian Competition Authority.
Yes, hello. Thank you for the introduction. Can you hear me?
Yes, loud and clear.
Perfect. All right, let's get started. I don't have much time, but I'll try to be as clear as possible. So talking about labor restrictions, we did hear that there are a few cases out there, but Estonia did have one recently. So late 2023, early 2024, we had a case involving Pindi real estate. To really make it short and understandable, it came to our attention that there was a contract that was given by Pindi to the implementers of Pindi's mission, who was a real estate agency. So it wanted to hire agents, and those contracts, actually those agreements, had two sub-agreements within them that made the whole agreement as one. So one of those sub-agreements was between Pindi and the implementer firm. The second agreement was between the implementer firm and the actual physical person. We did find out in the end that oftentimes these were individual firms. However, in the beginning, it was a red flag to us. Why would, or it became interesting to us why there would be two sub-agreements within one bigger one, tying both of them together, of course. And the red flag, the main point of this agreement that interested us was in the annex that was part of the agreement, where the agent, so in the end, the physical person wouldn't be able to compete either with the client in the activities or with competitors of the client in the whole Republic of Estonia. And so to us, for us, these were grounds to suspect some limit in the market for goods, services, or investment or otherwise, or also maybe a sharing and restricting access to a certain market. So that was the suspected harm or violation, and so we sent out our requests for information. Pindi was being really cooperative, and so the resolution came very quickly. They told us they had never applied that clause. That clause would effectively have meant that the physical person, if applied, wouldn't have been able to work at all in Estonia in the field that they have had a profession in for 6 months. As a side note, without compensation as well. But this wasn't a work agreement. This was a work agreement between companies, and then in the end with a physical person. So to us, it seemed curious. But from a competition point of view, this limited the entire activity of one firm, and thus fell out of the vertical block exemption. In our decision, we also touched on non-poach, although this was a non-compete. And we gave our point of view as a side note on non-poach, which is that overall, we agree with the policy paper that in most cases, these are by object violations.
Yeah.
Thank you.
Thank you for the overview. I will give floor also to the moderator of this current panel. This is Marika Krunte from our Latvian office, and she will take the lead over from here. We will have in this panel discussion also other speakers from Estonian Competition Authority, Piret Lohu, then from the Competition Council of Latvia, Matis Tselve, and Daumantas Krikinis from the Lithuanian Competition Council, the head of the Anti-Competitive Agreements Investigation Group. But last but not least, indeed, Marika, floor is yours to continue with this panel discussion.
Yeah, thank you, Kaupo, very much, and thank you for being here today in this interesting discussion. And maybe while we have just heard Estonian authorities practice, maybe two follow-up questions. Was the only issue during the non-compete, was the only issue the duration of the non-compete obligation extending beyond the validity of the cooperation agreement in your case you considered?
Yes. For us, as the fact of the matter only involved a non-compete, to us, yes, it was the fact that after the end of the contract, the service provider wouldn't have been able to work at all and would have been effectively in a void of sorts. So in this particular case, this was our main point of concern, indeed. Okay.
And the fact that you mentioned the vertical agreement block exemption in your decision, does it mean that the Estonian Competition Authority could potentially assess non-solicitation obligations similarly as non-compete obligations, do you think, in future? Or
this is an interesting question. We talked about it internally, but we'd have to sadly give a very typical answer, which is we'll have to wait for a case to involve those, and then we will be able to give more clarity. But for now, I can't give any more concrete answer to you.
Okay, thank you. Okay, then we can move on to Latvian authority, and maybe Matis, you could share your experience in Latvia if there has been some interesting cases in Competition Council's review.
Thanks a lot. So I think the closest that we have come in the Latvian Competition Authority to labor market restriction, well, to some extent, has been a case where the Competition Authority provided an opinion in civil court as amicus curiae, or quote, friend of the court. This particular case concerned a non-compete written in a shareholder agreement between two parties, where the receiving party sought to deem this obligation void based on the Latvian competition law, Article 11.1, which is, well, the national equivalent of Article 101.1 of the treaty. And so this specific provision held that the receiving party was forbidden from engaging actively or passively any of the undertaking's existing or past clients or partners in any kind of professional capacity for 3 years after leaving the undertaking. Or else the receiving party would have to pay approximately 28,000 euros for each instance where the said limitation would be violated. And by its opinion, the Latvian Competition Authority did not believe that this obligation was ancillary due to the fact that it was disproportionate. Well, there were many kind of unique aspects about the case, but the main argument was it shouldn't have been an all-encompassing limitation on all professional activity in any sector with regards to clients and partners, but it should have only been an obligation that covered undertaking's professional activity in the sector which it conducted its business in. So not an all-encompassing prohibition to professional activity, but a very specific one honed down to the sector where the undertaking was conducting its business. And so as for the outcome of the case, the first instance court rejected the claim, whereas and it was appealed, and then the judgment of the second instance court is due this week. So we don't know yet.
Okay, but exciting that perhaps we'll hear some news from the court. And yes, moving on to Lithuania and Daumantas, perhaps you could share your experience in Lithuania, whether you have had some interesting cases.
Hello. Yes, indeed. Pleasure to be with you today. So Lithuanian Competition Authority had two cases in labor markets. So one case concerning wage fixing and the other concerning no poach. So in 2021, Lithuanian Competition Agency adopted a decision finding that Lithuanian Basketball League and 10 basketball clubs, so members of the league, entered into anti-competitive agreement when they jointly decided not to pay basketball player salaries or any other financial compensations for the rest of basketball championship after its early termination due to COVID pandemic. So basically, competing basketball clubs agreed on a common position towards players' remuneration. So the theory of harm was that all basketball clubs were in different positions in relation to the basketball players' contracts, both in terms of the salaries agreed and contract termination consequences. So in the absence of such agreement, consequences, like financial, reputational, of the suspension of the basketball championship would have been different from each basketball club. This could also mean a different position of each club before the new season. The other effect the agreement had was also an effect on players who actually lost a rather significant amount of their income due to this agreement. So the agency considered that the agreement not to pay player salaries was a buyer's cartel, so price fixing for the purchase of basketball player services, and considered it to be an object restriction. So this was the first case we had in the sports industry, and as well the first case which is related to labor markets. The next case, which again, relying on the analysis carried out in the basketball case, the authority adopted a decision related to the real estate sector, which concerned no poach agreement within the Association of Real Estate Agencies. So in 2022, the agency established that Association of Real Estate Agencies and its members have agreed not to compete for each other clients as well as for real estate agents. This agreement was enriched in the Code of Ethics of the association, and the Code of Ethics basically prohibited real estate agencies to contact brokers of other members of the association by any means, so calling, contacting, email, etc. This agreement was also implemented in practice, and there was also a monitoring mechanism in place. So there was an association ethics committee which regularly investigated claims on potential infringements and issued warnings or even recommended expelling members from the association for non-compliance. So similarly, as in the basketball case, the authority held that the agreement had effects on several dimensions. So first, affecting the real estate agents by reducing their negotiation power, decreasing labor mobilities, and impacting their wage levels. And second, the agreement restricted competition between real estate agencies, since it limited the ability to expand output, provide better quality services. So this agreement was also considered to be a restriction by object, and both cases are now pending in the courts.
Okay, thank you. It's very exciting. At least two cases in Lithuania. While you have still the microphone, if we can say, perhaps we can move on to the next question that comes into our mind, and you could, Daumantas, comment and later other authorities, whether local authorities in Baltic countries have consulted market participants on labor market restrictions. And if yes, what are the main guidelines you have provided? So maybe Daumantas, you could continue on this.
Indeed. So following the two cases we had in 2023, we issued guidelines on agreements in labor markets which focuses on naked, no poach and wage fixing agreements between competitors, and basically sets the main principles on how we see these kind of agreements. So I would maybe start with a general approach we take towards agreements in labor markets. And nowadays, a lot of discussion around labor markets talk about how this is a new thing, a new trend, and that there are a lot of challenges because of that novelty. But from our perspective, agreements in labor markets is basically just another form of cartel. So when we look at product market cartels, we expect companies not to engage in price fixing or market sharing, not to exchange commercially sensitive information. And basically the same is true for labor markets. So we expect companies not to engage in naked wage fixing or no poach agreements, since they have straightforward negative effects. So as mentioned, first, they affect employees by reducing wages, their workers' mobility, and just simply denying workers from a possibility of a better living. And second, such agreements have effect on the market where the companies compete, by again reducing the possibilities to even innovate and expand. And lastly, there is hardly any legitimate justification for these type of arrangements apart from the goal to avoid competition. So therefore, we consider them to be restrictions by object, and the cases I mentioned illustrate that. So I would say there isn't such a difference, and you can also draw parallel when you look at biocartels. We see agreements in labor markets as a form of a biocartel. And as it was mentioned, we don't have much case law in labor markets, although cases are emerging. And just last week, we saw a judgment from ECJ on FIFA transfer rules, which were considered to be anti-competitive. But we have case law in biocartels, and the same principle can apply. So we set out this approach in our guidance to really make it clear on that this is how we regard it. That said, I do think it is important that we, as an enforcement authority, understand the context in which these arrangements occur. So we do hear examples of pro-competitive reasons for some sort of agreements in labor market sphere. So we do think it is important to look at it on a case-by-case basis. So it was already discussed today that typically these might include no solicitation clauses in otherwise lawful agreements. So, for example, service agreements, joint ventures, mergers, where such clauses might be objectively necessary and totally lawful. So probably the takeaway message is that context is important, but as far as naked restrictions go, there's a strict policy towards that.
Okay, thank you. Mattis, perhaps you could comment about Latvia.
The Latvian Competition Authority has published a brief press release on no-poach agreements. But other than that, I'm not really aware at this time that we have had any substantial consultations with private parties on this. As for the press release, it lays out in very general terms what no-poach agreements are, and that these agreements, in comparison with non-compete obligations, are agreements between undertakings on their labor force and not agreements between the employee and the employer. To that end, it notes that such terms are typically not known to the employees, as they do not get written in labor contracts, which also denies them the chance to object to them. And this press release also emphasizes that no-poach agreements are likely in sectors where only a very few highly skilled, highly specialized, highly coveted, desired, needed experts exist for the particular relevant market. And this can especially happen in very niche markets. And finally, the press release just generally declares that it is forbidden for competitors to agree on not recruiting competitors' employees, as well as it is forbidden to coordinate between each other the salary level. So all in all, or in other words, it's all decently general without any in-depth dive or analysis on anything so far.
Okay. Estonia, how is the situation there with guidelines or consultations provided?
Yes, thank you. Well, after the Pindi case, we of course had one law firm approaching us and asking very brief information about the case. And therefore, since we so far haven't had any specific case experience or so-called case law in Estonia, we haven't published any guideline yet, but we are definitely thinking about publishing the same kind of very general brief as my Latvian colleague mentioned before. Obviously, without the exact case practice, it can only be very, very general, and it's probably going to base widely and roughly on the Commission competition policy brief. But just in order to provide it in Estonian language, we are planning to do it.
Okay, thank you. Then perhaps next question. considering Commission's policy brief, which treats all non-solicitation clauses as by object restrictions, have you thought if it would be possible to apply the vertical agreement block exemption to non-solicitation clauses in vertical agreements which are limited to employees providing services under the respective vertical agreement? We understand that this is a bit theoretical questions, and of course authorities can only give general thought, but maybe you could share your thoughts on this. Maybe we could start from Lithuanian colleagues.
I believe everything depends on the context of the agreement and then where it takes place. Commission policy brief states that basically a distinction between agreement not to hire and not to approach competitors' employees, nor does different scope or structure of these agreements does not have any influence on the conclusion that it can be a per se infringement, basically. So personally, I agree with this, with the Commission as far as naked restrictions go, and as mentioned, there are hardly any legitimate justifications for such kind of agreements. Therefore, they are treated accordingly, and I think this is more or less the general consensus across a number of competition authorities around the world. If, however, we talk about situations where non-solicit is a part of otherwise lawful agreements, so again, service agreement, that is a bit of a different animal requiring, I think, a case-by-case analysis. As already was mentioned previously, such restrictions, if objectively necessary and proportional, serves a completely different and legitimate goal compared to naked non-solicit agreements and may be perfectly legal. And I think this is true for the Commission, which states in its policy brief that no-poach agreements may qualify as ancillary restraints, however, subject to strict conditions. As far as legal qualification goes, probably no good news here. And then a general rule is that vertical block exemption does not apply to agreements between competing undertakings. And since we're talking about competition for employees, it means that undertakings which compete for the same employees are considered to be competitors, despite the fact that they might operate in different product markets.
Thank you. Mattis, do you have something to add?
Yeah, I completely agree. Well, I could also just say that I think it was hardly ever a surprise that non-solicitation clauses in the Commission's policy brief, that they have been emphasized as likely restrictions by object. I mean, both the guidelines of revised horizontal block exemption regulations published in 2023 and guidelines on collective agreements quite explicitly refer to no-poach and wage fixing agreements as likely restrictions by object. And so the policy brief is essentially just following those two already out there conclusions, and since non-solicitation can be treated as a form of Article 101(1)(c), I would agree that these are likely restrictions by object. As for vertical block exemption, I would say that the block exemption regulations are typically not very kind to by object restrictions. Furthermore, the basic premise of Weber is that it essentially clears vertical agreements under Article 101(3) in regards to which it is sufficiently certain that there are efficiency gains, and I don't think that can be genuinely said about the no-poach agreements, as well as, yeah, as Domantas said, there is this Article 2.4, which would likely restrict the application of Weber to these cases.
Thank you. Yes, and perhaps Piret, you have something to add on this question.
Well, I don't want to waste anybody's time, so actually I don't have anything new to say. but of course simply emphasize that this is a very complex issue, and since even in Europe there is not really any relevant case law, then unfortunately only time can tell where the truth lies.
Yeah, that's true. So we have several more questions, but I'm afraid that we are running out of the time. So I think we could wrap up this part of discussion. And yeah, I think that considering that this, how to say, case law in Baltics is still very limited, there is certainly room for discussions, and also perhaps lawyers can express their views on topics which have not been perhaps clearly covered by existing guidelines or case law. So let's see how this topic develops, follow it, and perhaps in a couple of years or less we can return to this and see what has happened since last time. So Kaupo, perhaps I can give a word back to you.
Yes, thank you. Thank you, Marika. Thank you, Eugen. Thank you, Piret. Thank you, Matis. Thank you, Taumantas. And once more, thank you, Marika, for a good discussion and good moderation. I mean, I got from here a very clear message. There is potentially an elephant in the room. Nobody knows which way the elephant will run, but the labor market restrictions will be more in the focus for the competition authorities and are likely to get more scrutiny in the future. So I think thank you for this delivering that's a very important and critical point. But now we have time for the next panel discussion. This will be Sorainen only, all our countries represented: Sorainen Estonia, Pirko-Liis Harkma, Andris Burkevich from Sorainen Latvia, and Algirdas Pekšis from Sorainen Lithuania. All of them are employment law experts, really esteemed and established long-term experts, and they will be talking about legal possibilities still to protect trade secrets and investments in the employment agreements. So please, Pirko and the team, floor is yours.
So yes, thank you. Let's proceed with methods that can be used in individual employment relations. There are quite a few of them, and let's take at first a look at how these can be applied in Estonia. The first three are the most commonly used, and the most important one out of these is actually the confidentiality or non-disclosure obligation. And it is very important because it also serves as a basis for any non-compete obligations. Confidentiality obligation actually derives straight from the law and is thus not contractual. But for it to be triggered, however, the employer has to notify the employees of the contents of the confidential information. And based on our recent court practice, such notification has to be quite detailed and needs to distinguish between business secrets and other confidential information. This is due to the fact that not everything can qualify as a business secret. And in order to be able to take specific measures that target specifically breach of business secrets, for example, imposing also criminal liability, such a distinction is very important. And it is also recommended that when you notify the employees, you also notify what can and cannot be done with the confidential information. And the only contractual element here is the contractual penalty that you can agree upon for the breach of the confidentiality obligation. All other options, however, are contractual. And if we first take the non-compete obligation, then there are certain mandatory elements on which the parties need to agree on for it to be valid. If these elements are missing, then it could be that the non-compete obligation is also void. So what you need to agree on is who are the competitors, what is regarded as competing, where the restrictions apply in terms of geography, and whether the restrictions are valid only during employment or thereafter as well. When it comes to post-termination restrictions, then these can be agreed on for a maximum of 12 months. And you also need to agree on a reasonable monthly non-compete compensation for the restrictive period. And the amount of this is based on how restricted the employee actually is when choosing their next employment opportunity or next activity during the restrictive period, and whether it's likely that the employee would suffer a loss of income due to the restrictions. It is also possible and recommended to agree on contractual penalties. And if the employer finds that the non-compete obligation is not needed anymore or doesn't want to enforce it for the post-termination period, it is possible in Estonia to cancel it also by giving the employee 30 days of prior notice. Transfer and licensing of intellectual property rights is most important for IP-centric businesses. To some extent, the IP rights transfer to the employer already by virtue of law. However, moral rights that are non-transferable have to be licensed to the employer in order to allow for the use and commercialization of IP rights to full extent. And licensing requires to enter into an agreement with the employee to set out all the relevant terms and conditions for it. Now, retention bonuses, otherwise also known as stay-on bonuses, are less traditional, at least in Estonia, but they are used. And the main purpose of using these is to lock in talent, skills, and know-how for a certain time period. This means that the parties can agree that if the employee stays on for a specific time period, contributes to a specific project, they will receive a bonus in the end of such time period. If the employee leaves earlier, the bonus is not paid or is paid proportionately. So to some extent, it could protect the investment and know-how. Then compensation of training costs. It can be used, but I think in Estonia it's quite often used in a not legally correct manner, because when used in a correct manner, it does not protect always all employer investment in employees. Namely, agreement on compensation or repayment of training costs can be concluded only with regard to such trainings that are part of the employer's own training obligation. This means that these are non-mandatory trainings. Thus, it cannot be used for a repayment of costs that are related to improving the skills and know-how or other aspects that are crucial to the business and where the employer has mandated the employees to participate in. It can be used, for example, if the employee approaches the employer and says, listen, can you support me in acquiring an MBA degree or something like that. And lastly, gardening leave. This is not regulated under Estonian law, but I'm sure you've heard it's a concept widely used elsewhere, mostly in countries where non-compete obligations are not possible to agree on overall, or where the enforcement of these is complicated. And gardening leave is the concept when the employee is given notice of termination, or the employee themselves gives notice of termination of employment, then the employer can ask the employee that they do not come to work, do not perform duties during the notice period, basically stay at home and can tend to their garden, hence the name of this concept. And the employee during that time period continues to receive their salary. This is kind of a cool-off period. The employee would be away from the most sensitive information for a certain time period. The contract is still valid. They cannot go to work for any other employer. But again, the downside here is that the employee's consent is required. Under our law, the employer cannot unilaterally put the employee on garden leave. So it can be used if the employee agrees, but in many cases, the use of it is also limited. So this concludes what is the situation in Estonia, and I will now ask Andis to tell us about what is the situation with these options in Latvia.
Thank you, Pirpulis. Yes, hello everybody. My name is Andis Burkevits. I'm dealing with employment law issues in Sorainen Latvian office, and yeah, nice to be here. Just straight to the point. So, I will divide my presentation into two parts. So. One is what concerns employees' obligations during employment relationship, and during that period everything is fine. The employee is required by law not to disclose the employer's commercial secrets or business secrets or any other information. As in Estonia, the employer is required to present quite detailed description of such information, because the employee can always claim that he or she didn't understand what information comprises such secret. Also, during employment relationship, the employee is expected not to compete with employees, with the employer in any other way, not to enhance away the employer's clients, customers, cooperation partners, and employees. Though this obligation can be derived from the law, so it is always recommended to put it clearly in employment contract. And then if the parties agree, and this is usually a standard, then the employer can restrict any side employment of the employee, but any such restriction must be justified, because the employee always has the right to request the employer's permission for such side employment. After employment termination, then the situation is much more complicated. So the employee is still under obligation not to disclose the employer's commercial secrets, but it is still recommended to include such explicit obligation in employment contract. What is also important, like in Estonia, so there is a division between business or commercial secrets and other confidential information. So the level of protection of the business secrets is much more higher than for other type of confidential information. So and commercial secret will be information which has been which is secret, which is not known for other parties, which has some commercial value, and which is sufficiently protected. For example, confidential information would be personal data of employees and customers, so which is still protected, but this is not a business secret. As to non-compete restrictions, post-employment non-compete restrictions, then they are possible, but it is not. These are not very common in Latvia due to several reasons. So post-employment non-compete agreement requires that the employer pays a reasonable compensation. In practice, the reasonable compensation is 50% of the employee's salary, something around that. If the amount is lower, then there might be disputes whether this compensation in a particular case is reasonable. Also, the law sets quite strict rules regarding employers' unilateral right to withdraw from these post-employment non-compete restrictions. So the employer can do that only simultaneously with the employer's termination notice. So if the employer for some reason doesn't do that simultaneously with the employment contract termination notice, then after that it is too late. And in case the employee is the one who initiates employment termination, then until the last working day. So in any event, such non-compete agreement can be cancelled after the last working day of the employee. One interesting thing is that under Latvian labor law, then, for example, non-solicitation obligation is regarded as part of non-compete obligation. So this is not a standalone obligation. It is also possible to agree on contractual penalty in case the employee breaches non-compete obligation. What is interesting feature, so if the employee is on post-employment non-compete obligation, then he or she doesn't qualify for unemployment benefit. And if this restriction is too strict, then the courts will not annul it at all, but just the part which is too strict. So if the non-compete obligation will state that the employee cannot compete with the employer in the European Union and the UK, but the employer is only active in Baltic countries, then if the employee will breach this in the Baltic countries only, then that would be still fine, irrespective that this obligation was much broader. As to IP transfer and licensing clauses, then by law, if the parties have agreed on that, then economic right to IP products, so to say, produced by the employee belongs to the employee, but there must be such agreement in employment contract. Moral rights cannot be transferred, but usually what is included in employment contracts is that the employee will not use moral rights against the interests of the employer. As to retention bonuses, they work in Latvia exactly in the same way as in Estonia. Whether they are very motivated or not, then that would be more question for a business. But it's still possible to agree that the employee has to stay with the company for, let's say, 2 years to qualify for the bonus, and if the employee leaves even single day before, then the bonus will not be paid. As to the payment of training costs, the situation in Latvia is again the same as in Estonia. So such agreements are basically allowed only in cases these trainings are voluntary. So initiative comes from the employee. They are not essentially tied to the job functions of the employee, and basically so the maximum amount is 70% of the training cost. The maximum period when the employee should stay with the company is 2 years, and this training cost amount is reducing. So if the employee is with the company for 1 year, then if he or she leaves, then the employee must pay only 35% or half of the training costs. Gardening leaves exactly the same regulation as in Estonia, so they are used in practice, though they are not prescribed by the law. But as the employee is paid, then we haven't heard about any disputes regarding gardening leaves. Thank you.
Good morning. My name is Algirdas Pekšys. I'm a partner in charge of employment in our Lithuanian office. So I'll briefly touch upon Lithuanian specifics when it comes to the labor law. Yeah, very many similarities with Estonia and Latvia. I think that most popular restriction is actually non-disclosure agreements. In fact, this is probably the only area where the law also protects commercial secrets of employers. So basically, even if there is no non-disclosure agreement concluded with an employee, still the law protects trade secrets, but it doesn't go beyond this and doesn't concern other confidential information. This is why it is, a strong recommendation always to agree with an employee on additional confidentiality on non-disclosure agreements. The purpose is, to extend kind of the scope, not only to trade secrets, but also to other confidential information. Also to include pretty detailed list of this information so that it is clear for employee what is trade secrets and confidential information. Also, in such agreements, you could prolong the protection periods because kind of the statutory term is 1 year, but in the contract you could prolong it to 2, 3, sometimes we see 5 years, and also you could agree on certain sanctions. Interestingly, and probably differently from Latvia, non-solicitation of employees or non-solicitation of clients in Lithuania is considered to be a part of NDAs, of non-disclosure agreements. So basically, it means that you could agree as part of non-disclosure agreement that an employee, when he leaves you, he cannot solicit employees or clients because he possesses certain commercial information which could help him to do that. So basically, non-solicitation provisions are part of confidentiality, and you don't have to pay for that differently from non-compete. So on non-compete, situation is such that it's regulated by the labor law. The maximum term post-termination is 2 years. You could agree on them only in relation to direct competition to the employer's activities. So basically, you could just prohibit the person to work for competitors, not for other market participants. It should be remunerated, and remuneration, the minimum is 40% of the salary of the employee, but it could be more. So briefly on non-competes. Then other topics like IP transfer, it's very popular, pretty standard to include with IP-centric employees. So probably no other specific here to elaborate on. Retention bonus, as any other kind of incentives, also they work in practice and they are pretty often used if you want to retain an employee for longer periods. On repayment of training costs, so it's possible to agree with an employee that he has to compensate you the costs when he leaves voluntarily or he is dismissed due to his faults. So the maximum period is 2 years backwards when you could get this compensation. But that's tricky, the same as in Estonia, because actually you could agree only on compensation of such training costs which go beyond what is required for the role of that particular employee. And also, if you instruct the employee to go to certain trainings, also normally you wouldn't be able to get the training back. And the last point is on gardening leave. Again, the concept doesn't work in Lithuania the way it works elsewhere. You could actually put an employee on on leave, so to say, when he gives you a notice that he leaves. So the notice is just 20 days. So you could tell him not to work. Formally, the labor code requires his consent. But in practice, you either include this consent already in employment contract, kind of, in advance, or just don't bother too much about that and just put him on leave because it's more important for you to get a certain cool-off periods. I probably stop here because I know that we are running out of time. And Kaupo, back to you.
Yes, thank you, Pirko-Liis and Algirdas and Andis for a really good and insightful overview. I remind everyone that you have actually a possibility to ask questions in the chat, of course afterwards as well, but in the chat during the seminar. Now it's a time and place to introduce the next panel discussion. We will have a discussion on maximizing restrictions in employment agreements, and is it a win-win or lose-lose or win-lose or what not. And the speakers will be Piive Lehtsaar, Pirko-Liis Harkma, and Madara Mančiska. We will have a very experienced but youthful panel. Piive Lehtsaar is a competition law expert from Sorainen, Estonia, and having 15 years of experience in that field. Pirko-Liis, you heard Pirko-Liis. Pirko-Liis has been handling employment law matters for a little bit more than 20 years. Amazing. And Madara has had an equal experience from traditional banking and fintech product development, product management, and now she's head of sales at Tilde, which tries and works hard to take away the burden of different languages. So Tilde is in machine learning and innovation business, machine learning, machine translation business. So very, very diverse. And this time I'm moderating. So I asked the first question. Mainly the first question is to Madara and Pirko-Liis. Based on the earlier discussion and your experience, I mean, are these labor market restrictions, are they relevant? I mean, we heard they are highly controversial. We heard that they are perceived potentially highly problematic from competition law authorities. Yet, I mean, all the agreements are infested with all the employment agreements, not all, but many of them are infested with all sorts of restrictions. But do we really see that these restrictions are practically enforced? Are they relevant? What are your views on this? Perhaps Madara, coming from the what we call business side.
Thank you, Kaupo, for giving me a word. So I think from my experience and what I have saw working in different sectors, from traditional banking to fintechs and IT companies, the restrictions are unlikely to maintain and keep the valuable employees. So the one point that people are quite creative if they want to break those restrictions. From the other point, this is not what motivates really valuable employees to stay at your company. And it's like, as we mentioned before, the golden handcuffs that you are putting on them. And it's always about the matter of the price, what you are asking from them, and how much those restrictions are somehow giving them less opportunities in a future career. So yeah, so I would say that this with this kind of restriction motivation is not working on valuable employees.
Okay, thank you. Pirko-Liis, what are your thoughts? Are these clauses relevant, or are they something that is put in the agreements just because they have been there for ages?
They are quite relevant. As lawyers, we tend to be overly cautious sometimes, but what I have seen in my practice is that when companies actually do not pay in the beginning too much attention on protection of their business secrets or preventing employees from going to their competitors, then they quite often regret it, because in employment relations usually everything is very good, and until the first conflict or until some employee tries to take over your business or so on. So if you haven't really paid any attention to these restrictive covenants, then we as lawyers cannot help you later on if you want to have some sort of relief if someone has breached the non-compete obligation or disclosed your trade secrets. But I also see that it's quite tricky to agree on those obligations, because employees are more and more knowledgeable. They don't want to restrict themselves to that extent. And on the other hand, employers are sometimes afraid to propose these either in the beginning of the employment relationship or in the course of it, because it might frighten away good employees. And it seems quite kind of maybe bureaucratic a little bit to agree on all those details in such a manner. But what I would say that as a basic minimum, if you have a business that has a competitive edge and you have business secrets that you need to protect, then as a basic minimum, agree on the confidentiality at least. All the rest is something that is contractual in any case, requires employees' consent, and you may not get that. But if you have a good confidentiality clause, you may be able to say something if the case comes to that.
Yes, thank you. I mean, indeed, let's say confidentiality clause and IP protection clauses. These are seem to be pretty non-controversial and sort of understandable. But when we talk about more intrusive limitations like non-competes agreements or also non-solicitation agreements with your cooperation partners, does it really make sense to have these clauses in all agreements, or what is the best practice? Say how to look at where to use this tool and where not to use this tool. And Pirko, perhaps you can help me out. Otherwise, I'm talking alone.
Yeah, it's I would say that these tools, you cannot also use them as a blanket for everyone. You use them for key employees, and you use them for employees who actually handle this confidential information. But of course, it prevents movement of labor, it prevents innovation, and so on. So we don't know actually what is going to be the fate of these precisely the non-compete obligations, as we heard earlier as well. The trends from US are such that they want to ban these, although this ban is now disputed in court. But in Estonia, I think we have had the opportunity to use these non-competes for a long time, and these are quite well regulated and quite well also enforceable. So as long as there is opportunity to use those, I would still encourage you to use those. Look also to the other less kind of restrictive possibilities, but as said, these are not applicable in all cases. So the traditional ones like confidentiality, non-compete, IP, these are the basic ones. The others are maybe usable when you have not been able to reach an agreement on the first three. So.
Yes, thank you. Yeah, Madara, you wanted to add something, or?
Yes, I want to add that also from the company perspective, I agree to the colleague that that's nonsense to apply it for all the employees, but only for the valuable ones. But also from the company perspective, you have to think that these restrictions are paired with this financial compensation, and that you must ensure that you has that kind of resources to meet these obligations. So you have to take into account how many your valuable employees have these kind of clauses in their agreements. So you have to be sure that you will have that kind of budget also in the future to cover this.
Yeah. But now, when I have you here, Madara, already, let's say the question to you and also to Piive is that how do you perceive that the markets has markets acknowledged the competition law risks related to labor market restrictions with competitors, with employees? Is this something that people understand, that when they are working on these clauses, this is a potentially high risk in the future, perhaps even the risk going higher? Or is this risk material not acknowledged yet? Madara first, perhaps, and then Piive.
I think that the biggest part is not still acknowledging this, and so maybe Pirkko can take it. I will prepare my answer. I have to put my words into my head.
But Piive, please.
Well, in my experience, I would say that companies often do not understand why they can put non-compete obligations in employment agreements, but cannot do anything similar in agreements with other companies. So I would compare it to the not in my backyard movement in real estate and infrastructure development, that competition law says that, well, don't do it in agreements between companies, but it's okay if you do it in your employment agreements. Whereas the result might be that the market is more restricted overall, because companies just in case put as restrictive as possible non-compete obligations in all their employment agreements, because the employees' roles might also change during the the employment period, and it's not you need the employees' consent to make changes to any restrictions in the agreement. So if the employers just in case cover the majority or a huge part of the employment force with the restrictions in employment agreements, then for me it's an issue. Is it really less restrictive to recommend to companies to use labor market restrictions in employment agreements instead of less restrictive provisions in some specific agreements that they conclude with their customers or suppliers?
Thank you. But now, Piive, when you are already here, let's say we need to wrap these things up. What are your recommendations to clients how to tackle the labor market restriction, whether to maximize them or minimize them, or how to balance? What are your recommendations?
Well, you heard what the competition authorities had to say, and you can all read what the European Commission has said in its policy brief on intercompany labor market restrictions. For now, if you're not really looking to take risks, it's safer to put all the labor market restrictions to the extent the national labor laws allow this, and then you are able to negotiate with the employees to put them in employment agreements. If you really see that in a specific agreement there is a need for a no poach agreement, then you would need to seek legal advice. I wouldn't put it beside also the idea to consult the local competition authorities on their views, whether in this particular case, because you also heard that the authorities say that every restriction needs a case-by-case assessment, whether they would agree that in this particular situation the restriction could be justified also under competition law provisions.
Thank you, Piive. Madara, would you also like to give a recommendation to the to the market and then fellow business community, and also Pirko-Liis. So after your final words, we will conclude.
I think while non-compete agreements may be perceived as an effective and potentially lower risk by the employers, both non-solicitation and non-compete clauses are subject to increasing scrutiny, and especially as regulatory bodies aim to promote market competition and employee mobility. And this could affect the talent moves slower, and these are there are other methods that we could refer and use of retaining employees, and not to also share our trade secrets within the industry, because in Tilde we also see we have very smart PhDs that is working in European level on developing language technologies, and they are motivated by other things, by very interesting projects that European Union gives to them, and it's very hard for those employees that are highly motivated by the core of the work. It's very hard for the competitors to poach them or to attract with another job offer. So I think it's a lot about the content and about the relationships, how you are building with your employees, and about that these people also understand that they cannot share the trade information or the secure information that you have within your company. Yeah.
Okay, thank you. That's a very insightful comment. Pirko-Liis, you want to also add some words of wisdom?
I actually agree with Madara that in order to retain your talent and their know-how, treat the employees well, pay attention to your talent management, and whatever you agree on paper is one thing, but how the life works in practice is a totally other thing. And what I see in my practice is also that maybe companies do not really think through how they handle their confidential and sensitive information, that it's very easy to agree on something on paper or restrict competition, but actually I would urge everybody to think how the confidential information is handled in the company, who has access to it, how you disclose it, and what you basically do with it, because this would also minimize your risks, because agreements sometimes get breached, but if you haven't taken all the necessary steps in terms of security of information and so on yourself, then it could be a disastrous situation in the end when you lose your competitive edge due to loss of confidential information.
Yes, thank you, Pirko-Liis, thank you, Madara, thank you, Piive. And now it is lucky or unfortunate moment to conclude our webinar on labor market restrictions. As I said in the beginning, I hoped, and now I'm quite certain that you received nice food for thought and a bit of context to which direction the labor market restrictions are moving. What are the drivers behind the change? And you heard it from the authorities that labor market restrictions, they definitely demand more thinking through and analysis. So as the word was, context matters, and not all contexts are supporting labor market restrictions, especially when we're talking about the most strict ones. This confidentiality and IP protection clauses, they still seem natural, but when you start with garden leaves, non-solicitation agreements, especially with your clients, customers, then you still must be very cautious and really understand what is the context and why are you doing it and what is the general good that is coming out from this discussion, because as you heard from the economist, quite often when the problem hits the fan, then we discover that restrictions were in place, but they were not thought through, and unthought through and carelessly applied restrictions, they're just not enforceable and could result in additional troubles. So thank you for bearing with us. Thank you for listening. If you have any questions on the topic, then the people who spoke with you within and from Sorainen are in front of you. Feel free to reach out to them and ask their recent experience and guidance on these relevant topics. If you found this webinar so interesting that you want to revisit it, listen again, this or that part, good news, you can still do it. After a few days, this webinar will be available from our YouTube channel. Some of our materials are also available in Spotify. So feel free to listen, feel free to chime in, and if you feel that this webinar deserves feedback, good or bad, please give us this feedback, and most importantly, please let us know what are the topics that you would like to hear discussed by the best experts and market participants in the future. Just let us know and we do our best. So thank you very much and enjoy the rest of the day.